Good afternoon, sir. Can you see and hear us?
Yes, thank you very much.
Thank you very much. Mr. Parker, can we turn to the recommendations, the 8 of them, that Jonathan Swift made in his review? Who, in your view, was responsible for determining whether and to what extent the recommendations should be taken forwards?
So this responsibility I delegated to the General Counsel.
Why did you delegate responsibility for deciding which recommendations were to be taken forward to the General Counsel?
I rather assumed that all of the recommendations were going to be taken forward.
So I asked whose responsibility was it for determining which recommendations were taken forward, and you said you delegated that to the General Counsel.
I'm sure we discussed it, and obviously we ended up with a selection of different people looking after different recommendations, as I recall.
But before coming to the issue of who carried some of the recommendations into effect, was there a person who had a responsibility for determining whether the recommendations were taken forward or not?
As I understood it, the General Counsel.
You also said that you thought that all of them were going to be taken forwards. Is that right?
Yes.
So she didn't have anything to determine?
I don't think so, no.
Right.
Yeah.
So your understanding was that all 8 recommendations were going to be taken forwards. What role did the General Counsel, Jane McLeod, therefore play?
Her role was to work with the relevant parties and report back to me.
Is that the role that you delegated to her then?
Exactly.
Rather than deciding which recommendations were or were not taken forwards?
I see your point. As I recall, there wasn't a debate about which recommendations, but just to take all of them forward with appropriate parties.
Did it occur to you that the board ought to play a role in deciding the extent to which recommendations were taken forwards, and if so, how they were to be taken forwards?
We had a situation after the report was completed where, as I think I explained, the report wasn't shared with the board, and the understanding was the recommendations would be taken forward, and my plan was to share the outputs at that stage. So this was something that went straight from the General Counsel to the relevant parties, and so the board was not involved, no.
Was that a product of the legal privilege issue that we discussed this morning?
It was a product of the perception that I had with the legal privilege issue, yes.
Thank you. Can we look, please, at poll 00103190? And the bottom email, please. 13th of May, 2016, Jane McLeod to you. Here is my regular fortnightly update on the progress of your review and the litigation. Is it right that she provided an update regularly to you?
Yes. I mean, I'm sort of drawing that conclusion from the first sentence here.
Was the relationship between you and Jane McLeod essentially one-to-one, i.e. you saw her as driving the recommendations forward as appropriate on your behalf?
Yes, I think that's a fair characterisation.
She says, we can look at these quickly, helpline, in relation to the allegation that our helpline may have provided incorrect advice to sub-postmasters, which resulted in a loss to the accounts. Bond Dickinson, the external firm conducting the work, has now completed its investigations. Although some investigations were limited because certain records are no longer available and there were inaccuracies in the information provided by the complainants, their draft report reveals there is no evidence to support the allegations that have been made. We're currently reviewing the report ahead of it being shared with Jonathan Swift to seek his view as to whether it sufficiently discharges his recommendation in this area, but we're confident that it should be. And then Horizon System, we've had further meetings with Deloitte in relation to the extent of the work necessary to discharge Jonathan's 3 recommendations excuse me, on the testing of Horizon, and they have begun work on the substantive phase of that work. It's by its nature an iterative process that, dependent on early results, further decisions then need to be made on whether or not to explore further. I've asked the new CIO, Rob Houghton, to review the process undertaken by Deloitte to sense check these further decisions. Suspense accounts, Deloitte are also conducting the work into the existence and nature of the relationship between Post Office's suspense accounts and specific branch accounts over the relevant period. This is materially different exercise to the IT testing, and I understand that most of the relevant accounting processes were or are paper-based records and manual reconciliations. And prosecution practice, Jonathan Swift has confirmed that Brian Altman can limit his initial review to those 19 cases presenting the specific features of double charges in question and decide on the basis of those findings whether to extend the exercise. That work is ongoing. And if we go back to the top of the page, page 1, you say, I think there will be frustration at the time this is taking. Indeed, I'm also beginning to get somewhat frustrated. What's the projected timetable for completion of the components of the action list? Does that reflect the fact that the report had been provided to you in draft in January, in final version on the 8th of February, and it was now mid-May, and the work was inchoate?
I think that's true. That's what I was expressing at the time.
Did you pick up from the chain that the recommendations made by Mr. Swift were being trimmed?
No, not especially. Why? What's behind?
Altered?
I don't think so.
I mean, to take an example,
Yeah.
over the page, prosecution practice. Swift has confirmed that Altman can limit his review to 19 cases presenting specific features and then decide on the basis of those features whether to extend the exercise. That wasn't the initial recommendation. Recommendation was to review all of the cases, if you remember the recommendation number 1 and 2.
I see your point. I think I would have taken that at face value to mean that she had talked to Jonathan Swift, and between them they'd taken a view that that was going to respond to the recommendation adequately. I hadn't picked up, to be honest, that things were being, to use your phrase, trimmed as such.
Can we go forwards, please, to poll 0024 1554? We can see at the foot of the page your email. There'll be frustration, yes?
Yeah, yeah.
And then top of the page, please. You'll see that Jane McLeod forwards the email to, circulates the email to a small team of people, Patrick Bork, Mark Underwood, and Roderick Williams.
The very same people who received the copy of the original Swift report.
So it's the same select few.
Exactly.
Please see email from Tim below. It will be helpful to be able to respond with the status of each of the 8 question mark actions that were being carried forward, a description of the remaining work and expected completion time. We should consider the work being done by Deloitte and how far we want to address the questions posed by Jonathan. Just stopping there, was it for this small team to decide how far we, presumably the 4 of them, want to go to address questions posed by Jonathan Swift?
So I think I come back to where I started on this, which is that I assumed perhaps wrongly in retrospect, but I assumed that the General Counsel's team were A, competent, B, would do things in good faith, and C, would respond effectively to the recommendations of the report. Now, you know, when you get to see these emails that are shown to me or form part of the evidence base, which are what's going on, as it were, behind the scenes, it kind of puts a different complexion on things a little bit. So the reason I mention all of that is that, you know, I'm expressing to you what seemed to me to be the case. Behind the scenes, of course, you find that, you know, the motives for doing things perhaps are not quite as straightforward as one might have imagined.
There's no suggestion, from me at least, that this email was provided to you. Was it right for this team to be seemingly determining whether the recommendations were taken forwards, and if so, in what way?
So, in the world that I normally exist in, I have people working for me, and they have a job to do, and if I ask them to do a job, they understand and it's correctly specified. Until I got to the post office, I think I'm right in saying that throughout my career, I have found that people went and did what was asked of them with suitable determination and suitable application of their abilities. And so, in retrospect, you might say, well, these are not the right people because here we are at the post office. But I can only tell you that under normal conditions, they should and would have been the right people and could well have carried out these recommendations effectively.
Can I ask you two questions arising from that? Do I take it from that answer that if you had known that this small team had taken upon itself the function of deciding how far to go to discharge a recommendation, you would have had something to say about it?
I would have been concerned. I mean, it was straightforward. Here are the recommendations. You know, let's go and do something about them.
And the second thing is that you didn't therefore know at the time that this subsurface internal debate within a select team within Post Office was going on?
No.
The email continues, given the litigation, I suspect there's even less we're going to be able to say about the results of the further work, so we need to consider the value to be obtained from each step. Again, that's a similar point, i.e. The team determining value to be obtained from further work, in part based on the extent to which something can be said about the results of it. Does the same answer that you gave a moment ago apply?
I can see your point. If I may make one general observation about this sort of backward-looking, what were people doing 8 years ago type thing, that you can only look at the evidence that you have on a piece of paper. And people write sentences which can or cannot reflect truly what was going on. So I'm not here to, you know, doubt what's actually written here. But sometimes things that are recorded don't exactly reflect what people were doing at the time. I don't know in this case. I just think it's worth bearing in mind that you cannot take every sentence that is written and that you read as gospel in this context.
That's certainly the case. A number of people have sat in your chair and said that what they wrote does not reflect what they meant at all.
Very good.
Can we move on to poll 0010-3214? And look at page 2, please. And just scroll down. Thank you. It's an email later that month. We were just looking at the 14th of May. We're now looking at the 27th of May to you. And Ms. MacLeod says, as flagged at the board earlier this week, I hosted a call with Jonathan Swift today to ask what, in his view, would be a reasonable course of action for you to take in relation to his recommendations as to the further lines of inquiry which could be undertaken now that the post office faces litigation covering essentially the same ground. And so just stopping there, can you recall who told you and how about litigation being threatened against the post office on behalf of sub-postmasters?
I believe I must have been told at some point after the receipt of the letter of claim. Now, the letter of claim, I think, came in middle of April or end of April, something like that.
Can you recall whether you were told that this may have an impact on the extent to which the 8 SWIFT recommendations could be carried into effect?
I can't, to be honest. I don't know. I can't tell you whether this was the first, glimmer of that happening.
That's essentially what I'm driving at.
Yeah, I'm not. Honestly, I can't tell you for sure.
In any event, Ms MacLeod reports, in summary, Jonathan felt that Tony, that should be Degar Robinson, QC, the barrister retained to advise Post Office on its defence to the proceedings, should be requested to advise Post Office whether in the light of the litigation, the various works teams should be continued, paused, or redefined. So that's essentially telling you that she went off to Mr. Swift, who said, don't ask me in the first instance, go to the person that's conducting the civil litigation, Robinson QC, and ask him. Yes?
That is exactly as I understood, with hindsight, is what happened, yeah.
We will send instructions to Mr. Degar Robinson early next week and expect to have his advice relatively quickly. Once this advice has been received, Jonathan has said he'd be happy to discuss with you how best to take this forward in the context of your review, as well as considering how to position this with Baroness Neville Rolfe and others with knowledge of and interest in the review. Was this your main means of communication with Jane MacLeod, i.e. email, rather than attending the office and having meetings?
Oh, I'm sure we spoke about it. I'm sure she just sent me an email about it.
Okay. Do you think there was discussion outside of the email as well?
I honestly can't confirm that.
Can we go forward to page 1, please? And scroll down. On the 10th of June, Jane MacLeod writes further to the email that we've just looked at and says, we met with Tony Degar Robinson last night to discuss the postmaster litigation. In the course of that discussion, we asked him for his advice as to whether the work being undertaken for the purposes of your review should be continued. His strong advice was that the work being undertaken under the aegis of your review should not continue in the light of the litigation. However, he also recommended that the subject matter of that work should continue, provided it is rescoped and re-instructed for the purposes of the litigation. Clearly, you'll need to inform the Minister. We'll prepare a form of words, and then over the page, sign off from Jane MacLeod. And then top of page 1. Let's meet on Thursday to discuss, yes?
Looks that way, yeah.
Now, the SWIFT review was a significant piece of work, wasn't it?
It was.
It contained recommendations that went to the issue of uncovering potential miscarriages of justice.
It did.
It plainly took a long time to research and complete, and it was a comprehensive report, wasn't it?
Indeed.
Given that one of the reasons for undertaking the review and some of the recommendations from it related to matters touching on the safety of criminal convictions, did it occur to you that undertaking the recommendations through the aegis of civil litigation against the Post Office was not the right way forwards?
So I think we're back to this question of, in this kind of situation, which I had very little experience of hitherto. Receiving advice from senior counsel on a legal matter, very strong advice apparently, I took that advice and I assumed, perhaps erroneously, that the General Counsel, who also herself was a lawyer, would have considered and appreciated any implications, ramifications of doing this in terms of how the SWIFT report was carried forward. So it's a very difficult question because, you know, when you look at these things in hindsight, say, well, you could have spent some more time discussing it, or you could have had your own view, or you could have done this. The problem with experts or specialists is, how do you judge the view of the specialist? Do you get another specialist to advise you on the specialist? Or do you draw the conclusion that your judgment of the specialist was wrong and the specialist you've got is no good? Or that the General Counsel who is advising you is somehow incompetent? Or the whole bunch of them have somehow some rather nefarious, underhand objective of potentially holding things up? I'm not sure, but at the time, I took at face value what I thought was good advice and the right advice from people who apparently were qualified to give it.
So is a summary of that answer that you thought it reasonable to rely on the advice of your General Counsel, who had asked the Silk the very question that you needed to be answered, and he had provided an advice which was said to be very strong?
All I'm saying, and you're right, it's not a bad summary of my 10 or 12 sentences, that whether it came from Mr. Swift or and with Jane McLeod, they're both lawyers, they both understand what's in the report, they are and were both qualified, and certainly he was, to give a view, yes.
Do I take it that it didn't occur at the time that what might be in Post Office's narrow interests in the conduct of the civil litigation might not be in the wider interests of wrongly convicted sub-postmasters?
So I think we're touching on this question of, with hindsight, of course, it would appear that there were motives perhaps underpinning some of the advice or the direction of this that were not wholly fair or right or in the interests of people who had been wronged. At the time, however, it seemed to me that the people giving me advice should be and were doing this in good faith, and it was the right thing to do.
Thank you. Can we move forwards? Poll 0024-2402. And if we can go to page 4, please. This is a chain that you're not copied in on, but it attributes to you and to the Post Office some beliefs or intentions. So I want to ask you about them. It's the 8th of June now, an email from Andrew Parsons, the partner at the firm of solicitors that the Post Office was using to defend the threatened litigation, to Anthony Degard Robinson. And he says, Tony, I met with the Post Office litigation steering group yesterday. Just stop there. Were you a member of the litigation steering group?
I wasn't.
Do you know who it consisted of?
I do. I'd have to have a piece of paper in front of me, but in summary, it was a collection of Post Office executives and specialists and legal people.
Their approach to Jonathan Swift's recommendations has shifted slightly. Tim Parker feels that he has made a commitment to Baroness Neville Rolfe to follow through on the Swift recommendations unless he is presented with a persuasive case not to do so. Is that accurate, that you felt at this time you'd made a commitment to the Minister to follow through on the recommendations unless you were presented with a persuasive case not to?
Yeah.
So that's accurate. And then Post Office are looking to us, and frankly you with your magic QC seal, to give them some reasons for why Tim completing the SWIFT recommendations would be ill-advised. First, Post Office are looking to us, i.e. to the lawyers, and to Mr. Degar Robinson, to sprinkle some magic dust on the answer for reasons why the recommendations, completion of the recommendations would be ill-advised. Was that a message that came from you?
You mean this about magic QC seals? And,
No.
sorry.
Put aside the magic QC seal. The description of Post Office are looking to us for reasons not to complete the recommendations.
Yeah, well, you know, again, as you said at the outset, this is something that's going on without my knowledge.
That was the question.
Yes.
Was this going on without your knowledge?
And just to be clear, it was without my knowledge.
So you weren't looking for lawyers to come up with reasons not to do or undertake the SWIFT recommendations?
No.
Do you know who was? It's described here as Poll are looking to us.
Yes, I see that. Well, it's I certainly wasn't part of the, hey, you know, can you get Tony to give us some reasons why we should let up on this?
Yeah, some top cover, some
No.
legal insurance or other such phrases I've heard in my career. That wasn't coming from you.
That wasn't coming from me.
Did you know that in any way that there was a group of people within the Post Office looking to stifle or end the carrying into effect of the SWIFT recommendations?
The answer to that question is no.
If we scroll down, the recommendations we're talking about are, and then they're set out, 1, 2, and 3. My view, that's Mr. Parsons' view, is that the 3 recommendations plainly overlap with the issues in the litigation. I can see 3 reasons why Tim should not conduct the above investigations. 1, we, the litigation team, will need to investigate these points. We'll probably need to do this on a different timetable to Tim. We having a degree of time pressure, Tim under less time pressure. We will probably require a more robust investigation, given that these points could be tested in court. 2 parallel reviews could be wasteful and cause unknown complications should they reach contradictory results. Was any of this reasoning ever explained to you for not simply carrying into effect the SWIFT recommendations?
No, I had certainly not this kind of rationale, no.
2, if these investigations are conducted by Tim, there's a greater risk that this work is not privileged. It will be much safer for the investigations to be conducted as part of the litigation. Was that explained to you?
No, I think the one sort of view I had was that this review should be stopped and repurposed as part of the litigation, and because of the litigation, the work would continue to be privileged.
3, even if the risk in 2 above could be guarded against, say by classing it as part of SWIFT's ongoing advice to Mr. Parker, questionable, I cannot see how you, Mr. Parker, could disclose the results of these investigations to the department without a risk of waiving privilege, particularly where there's a possibility that Baroness Neville Rolfe may then speak to James Arbuthnot, or Post Office or BIS could be the subject of a FOIA request. Was that explained to you as a reason for not carrying into effect the SWIFT recommendations or any of them?
No, essentially, what I got out of all that was what you saw in a couple of papers ago, which is I can't remember the exact description, but it was something like the strong advice of senior counsel, the work should be discontinued and repurposed. I can't remember the exact form of words, but that is the advice that I received.
If we can give Post Office a piece of advice that says that you should stop any further work, you would then feel empowered to say to the department that on the basis of legal advice, he's ceasing his review. I'm conscious that this feels somewhat unpleasant in that we're being asked to provide political cover for Tim Parker.
Yeah.
However, shutting down Tim Parker's review is, in my view, still the right thing to do. The way that last paragraph reads, would you agree, is it implicates you somewhat in the making of the request?
Well, I mean, I certainly was not aware of all of this stuff going on, as it were. And it certainly makes me look a little bit, like these guys are marionettes and I'm sort of, doing my little thing in response to bits and pieces that they're putting forward. And that's, very disappointing with hindsight, because you, as I was explaining earlier, you expect to get advice from lawyers in good faith with, good motives and a good rationale, and I assumed that was what I was getting.
And so, directly to answer my point, to the extent that this last paragraph implicates you in the sense that it says that you would feel empowered to say, on the basis of legal advice, you are ceasing your review, and that they, the lawyers, are being asked to provide political cover for you. Neither of those things are things that you asked for.
No, I got the advice and then used the advice to essentially communicate with Bays.
So you
I
weren't
didn't. I didn't feel empowered myself. I wasn't aware of being empowered because I wanted a reason to go and tell Bays the thing was being discontinued. I received that advice, and as a result of getting that advice, I went and then communicated it to the civil servants and onwards to the minister.
Can we move forward, please, to poll 0024 2552? If we just go to page 3, please. Just to remind you, foot of page 3. We met with Tony Robinson to discuss the postmaster litigation. Second paragraph, his strong advice was that work being undertaken under the aegis of your review should not continue. Yes?
Yes.
10th of June. And then page 2 at the bottom, please. Um, 14th of June, see below, that's that chain, and your reply saying, let's discuss on Thursday. Jay McLeod and Roderick Williams and Patrick Borg in email discussion. Any approved messaging we want to get across? Did you know that the small select team were formulating messaging for you?
No.
Up the page, please. In terms of messages to Tim and from Tim to Baroness Neville Rolfe, I think we're going to have to address the issue head on. The litigation makes the review irrelevant, since the issues to be considered will be put to a higher standard of testing in the courts. Was that ever explained to you, that the review was now irrelevant?
I can't remember that it was explained in those terms, no.
Because of it is said, a higher standard of testing in the courts. That wasn't ever explained to you?
I can't be sure. I mean, I think the main reason this ended up where it did was the advice I referred to earlier, which is the strong advice from external counsel. Whether or not this was added, as a sort of a rationale, I can't be sure.
The email continues to continue would be fruitless, since we couldn't use its output, senseless in terms of expenditure, and present unnecessary risk to the organisation's legal position. Were those reasons for the review being irrelevant put to you?
No.
To my mind, in any event, it's now clearer than ever that the review, or indeed any other exercise not involving a third-party adjudicator, not a mediator, just isn't capable of putting these issues to bed in the minds of some. That does not need to be pitched as a bad thing. Yes, it frustrates the review and is uncomfortable, but it has the clear merit of being independently determined and final. Before you joined, I was racking my brain with others about how we might find a way of getting these cases, or one of them, into the court. None of this is new, but I do think the trick will be in the cell. Anyway, that's my view. Was it explained to you that the review was irrelevant because it wasn't capable of putting issues to bed in the minds of some?
All of these ruminations, which is from Patrick, is it Patrick Burke?
Yes, this is Patrick
Burke. You know, I had, as I've explained twice, the way it was represented to me was that Degar Robinson, who was the senior counsel, advised, and on strong advice, that the report should be discontinued and repurposed. I can't ever remember receiving all of the, you know, the product of this kind of thought piece or whatever, you know, so justificatory type logic. No.
Well, it might not just be a thought piece or justificatory logic. It might be revelatory of the true reasons operating on some people's mind for not continuing with the SWIFT recommendations. And they were instead badged up to you as needing to be stopped because the Silk had said so in strong terms.
You know, it looks that way, doesn't it?
Yeah. Thank you very much. They're the only questions I'm going to ask you about the SWIFT review. Can we turn to a separate topic, please? The conduct of the group litigation. You've addressed this in very considerable detail in your helpful witness statement, and therefore I'm not going to ask you about a lot of it because you have exhibited to your witness statement a very large volume of material, contemporaneous material, that explains your conduct and the conduct of those around you. So just a few topics, if I may. Firstly, can we look, please, at the one of the first excursions into court and the outcome of it, namely the strikeout application, by looking at poll 0010 3351. And look at the foot of the page, please. We're now in October 2018. It's an email to you, copied to others, from Jane McLeod. And she says, I understand Tom Cooper has recommended you read the judgment from the hearing last week, and it's attached. We received the decision on Monday evening, and the decision rejects our application for strikeout of significant parts of the evidence contained, I think that should say, in the claimant's witness statements. The application was decided on case management grounds for which the managing judge has considerable discretion. Applying that discretion, the managing judge set a very high threshold for strikeout and concluded that we had not established to the necessary standard that the claimant's evidence could never be relevant to the case, given the number of common issues, the considerable legal analysis each will require, and what our case on those issues is. He confirmed he will apply properly the law on admissibility when it comes to trial, and the November 2018 Common Issues trial will not rule on matters which concern Horizon or which whether Post Office actually breached its obligations to the claimants, matters to which most of the disputed evidence goes and which will be dealt with in later trials. As previously advised, this is consistent with the managing judge's approach of wanting to give the claimants their, quote, day in court one applying the orthodox legal position. That said, we lost the application and can expect the claimants to be awarded their costs when that question is dealt with on the first day of the trial, estimated to be £120,000. In deciding the application, the managing judge was critical of our conduct of the case, see particularly paras 55 to 57, including intimating that we were not acting cooperatively and constructively in trying to resolve this litigation, which criticism was levelled equally between the parties, and that we had impugned the court and its processes by making the application for improper purposes. This response is extremely disappointing, given the approach we've been adopting, and his challenge as to the purpose for which it applied for strikeout is at odds with the comments he made during the various procedural hearings over the past year. Nevertheless, we're refining our preparation for trial, including our reactive communications plan, in the context of the judge's remarks. And then back to page 1. You say, thanks, I've read the judgment, and the judge does seem to be somewhat negative about our efforts to take out elements of the evidence, even if he does acknowledge that both sides have been uncooperative with each other in the management of the case. My worry is that some of his points at the end betray what looks like an inherent dislike of our aggressive approach to the individual claimants, as well as an aggressive approach to litigation, as well as a rap over the knuckles regarding what the judge sees as using negative PR as part of our argument. Interesting to know if this initial response from him suggests any change of tack on our part. So I think, would it be fair to say you were concerned about the judge's criticism of the Post Office?
Yes. Was this, just to be clear, was this the case management conference number 2? I'm just trying to, get the chronology. So we had case management conference number 1, at which point he was quite critical of both parties, who he said were being uncooperative.
I think that was in March 17.
And this is number 2, is it?
I don't think it's actually CMC number 2. I think it's a separate strikeout application.
Okay. So progressively, the judge, as I read things, became more critical. And what began as a sort of fairly even-handed criticism of both parties, I think by this time he had started to become somewhat critical of the Post Office. And that's why I suspect I asked, so what do people think of this, actually?
The words that were reported to you and which appear in the judgment, namely the Post Office have made the application for improper purposes, are quite strong, aren't they?
They are. And also, one of our people, apparently, this is the PR reference, I think, said something like they felt some of the additional evidence could potentially damage the reputation. I can't remember what. So I knew what the issues were, and that was really why I was asking the question.
So you say at the end, interesting to know if this initial response from him suggests any change of tack on our part. Is that a question back to Jane McLeod?
Yes, I think, I'm obviously, without wanting to sort of immediately prod and say, look, it looks like you're wrong, I'm inviting a comment.
And that leads me to the question, what role did you play, therefore, in setting or amending the Post Office's strategy in the group litigation?
So I think you'll see, I don't know, there's another email chain subsequently where the point is made to Jane and there are various responses around a change of tack, etc., somewhere, I think.
I think that's much later.
Is it? I'm sorry. There's so many documents. It's hard to. So I'm not. I mean, I can't tell you if we don't have any documents exactly what the output of this was. At this stage, there's obviously some concern, but and the point has been made. I'm not quite sure what happened as a consequence of me inviting some kind of response here.
And so back to the question of what role did you perform? You weren't a member of the litigation steering committee.
Well, by this time, I may be wrong. This is 2018. we had formed the board subcommittee, and so I'm not quite sure whether this is in the context of the executives or whether this is something that was going through the board committee. I would presume that this was an exchange between myself and the executives.
Is that because of those that are copied in on it?
I'm assuming that, yeah.
Again, approaching the question from a different perspective, who determined the Post Office's litigation strategy?
So at that point, we had a board subcommittee, and the arrangement was that the executives managed the day-to-day elements of the litigation and were required to escalate any significant decisions to the board subcommittee.
Did government have any role in the strategy that the Post Office took to the litigation?
Well, Tom Cooper was a member of the board subcommittee, and one of the key reasons he was a member of the board subcommittee was because he was the BEIS representative on the board.
Can we turn forwards then to poll 00103352? Foot of the page. Same day, 18th of October, 10:30. Tim, have you seen the judgment from the other day? It's worth a read. And then further up the page. Your reply, same day at 2 o'clock. I've now read it. Judge is critical of both parties, but already sense he's not well disposed to us. The word aggressive is used a couple of times in connection with us in relation to the inadmissible evidence claim and the treatment of a sub-postmaster. The tone of his comments at the end on the common issues trial and the purported objection on our part for PR reasons is definitely not helpful. I've asked for an update on whether this ruling and its tone suggests any change of tack.
Yes, so that was the chain that I was referring to earlier, where I think we picked up, you know, the critical comments of the judge, and at that point was asking, so guys, what are you going to do about this?
And so what happened as a result? You've asked directly Jane McLeod, copied to Paula Venables, does what has happened on this occasion, resulting in the publication of this judgment, suggest a change of tack?
So
UKGI have sent the same judgment to you, saying it's an interesting read. You've replied saying exactly what you've done. What happened?
Yeah, so Tom and I were colleagues on this committee, and I don't know if someone can bring it up, but there is a subsequent email chain, and someone has spoken to Jane, and I think it was Paula Venables summarised a list of outputs from that discussion, which I can't remember which document is relevant to this, but there is one.
I will endeavour to search for that whilst other people ask you some questions, because I don't have it at my fingertips at the moment. So is the answer then that the primary vehicle for setting the strategy was the subcommittee?
Yes.
But there were back channels of communication, such as this one, in which members of the subcommittee communicated?
Yes, I think the broad, I can't remember there is a document somewhere with the terms of reference of the subcommittee, and from memory, it makes fairly clear that the management of the litigation is by the subcommittee, and executives who manage the thing on a day-to-day basis need to escalate matters to the committee as appropriate.
We shouldn't see this kind of communication as a means at which strategy was decided or carried into effect.
Well, I suppose in a way you've got myself, Tom Cooper, and I'm not sure if at some juncture Ken McCall, who was another member of the committee, would have been involved in this, but I mean, it at least is being dealt with, and two significant members of the committee are aware of it.
Thank you. Can we move forwards, please, to March 2019 to look at the recusal application? Can we start by looking at poll 302 3H98? And look at page 2, please. An email of the 15th of March 2019 from Jane MacLeod to you, Tom Cooper, and Alistair Cameron. She says, as flagged on the board call on Tuesday, we sought further advice on appeals and whether we have grounds to request the judge to recuse himself on the grounds of bias. So I think the board call previously was the Tuesday of that week. We sought advice from Lord Neuberger, who stepped down last year as President of the Supreme Court and was the highest judge in the United Kingdom. We sought his views as to whether the draft judgment demonstrated the following grounds for appeal, whether the judge has correctly interpreted and applied the law as to construction of a document or application of a principle of law, whether there are grounds to argue his findings have been made as a result of serious procedural irregularity, which goes to the admission of and reliance on, amongst other issues, inadmissible evidence, and most urgently, whether Mr. Justice Fraser demonstrated grounds on which we could apply for him to recuse himself. The test for recusal is whether the fair-minded and informed observer, having considered the facts, will conclude there's a real possibility the judge is biased. Attached is Lord Neuberger's preliminary note. The note is put together, or the note he refers to is put together by David Cavender, summarising the key extracts of the judgment and trial transcript. As you'll see in para 5, he states that although he has only looked at the issues very cursorily, quote, at least some of them raise quite significant points on which the Post Office has a reasonable case, and at least on the face of it, some points on which the Post Office has a pretty strong case. He suggests if we wish to rely on the ground of procedural unfairness at an appeal, the Post Office has little option but to seek to get the judge to recuse himself at this stage. And para 20, if we fail to act promptly, we risk being held to have waived our rights or at least weakened our position on the recusal issue. There's a timetable. The risks are if the application is successful and the trial is adjourned, we proceed with an appeal on the common issues trial and a new judge is put in place. The application is unsuccessful, then it's likely that the judge is further antagonised. However, he will be aware that the common issues appeal is progressing, which includes procedural unfairness or an assertion of procedural unfairness. Possible impact in that scenario is that the judge is more cautious as to behaviours to possibly Post Office's benefit. Over the page, theoretical downside to a recusal application is that it fails and that Fraser remains the judge at trial 3, which will require multiple findings of fact which are more tricky to appeal. We should also not proceed with this course of action unless we're prepared to appeal a decision by him not to recuse himself. I propose today to brief a further senior silk, probably Lord Grabbanner, to act on the recusal application. Next steps, this is clearly a board decision. We'd need to give the board time to consider the options. And then some practical arrangements, given that Lord Neuberger was in Argentina. Do you recall the issue of the recusal of Mr. Justice Fraser being raised in this way?
Yes.
What was your initial reaction, if you had one, to the suggestion that the Post Office should apply to a judge to recuse himself on the grounds that he was apparently biased?
So, if I'm honest, an element of unease. In a way, this is it's a bit analogous to what I mentioned at the outset of today, which is one of the things that would have helped to frame this kind of decision, and indeed the decision that were made at the beginning of this thing, would have been to know, for example, exactly how many postmasters had been convicted. And in the same way, in a funny kind of way, this, if I had had some meaningful statistics. I think if all of us had had some meaningful statistics about how often judges are accused, we might have looked at this in a slightly different way, because I have a suspicion it isn't very often. And I think one of the problems was that, if you take advice out of the context of the frequency of the events you're trying to evaluate, you sometimes end up with a slightly distorted view of things. And so, my gut feel, and I'd had something to do with judges, was this, I was a little bit uneasy, I have to say.
What was the cause of your unease?
Simply the fact that, it's quite a big deal to get a judge to accept that they had made a judgment that was wrong on technical grounds.
Can we go forwards, please, to poll 00103446? And scroll down to the foot of that page, please. Thank you. Slightly difficult to decode exactly what's going on, but it's an email to you of the 16th of March. And Jane McLeod says, below is my high-level summary of the call today. If we go to the foot of that page there, where the summary begins, participants, Kelly Tolhurst, MP, Tom Cooper, UKGI, Gavin Lambert-Bayes, you, Al Cameron, Jane McLeod. And then the text of Jane McLeod's high-level summary commences, and it goes over the page. And if we go to page 3, please. And if we look at the second bullet point down, TP, that's you, replied that we have a board call on Monday evening at which we will discuss issues around the judge's bias and how that could impact on subsequent trials. Although that's your initial reaction, is that this is not something that the board is likely to want to do. The board must act in the best interest of the company, so we need to consider that option seriously. If we're to make the application, it must be made urgently, not delayed, etc. So firstly, why were you having a meeting or a call with Kelly Tolhurst MP about, amongst other things, the judge's recusal?
Well, by that time, so just to give the background, so Tom Cooper was a member of the Post Office litigation subcommittee. And by that time, because not least the judgment in the Common Issues trial had been received and it was so damning, by that time, I think the department was becoming worried, concerned, and wanted a higher level of involvement. And Kelly Tolhurst was the relatively new, because it was a fairly fast revolving door over there, she was the relatively new Parliamentary Under-Secretary of State at what was called BEIS at that time, I think. And so the reason she was involved was that, Tom, I think, felt it was necessary to get the minister directly aware and involved in potential decisions that were being made around the judge's recusal.
What part did government therefore play in deciding whether to apply for the judge's recusal?
My assumption is, and I've no means of telling from this or indeed where I sit now, is that Tom Cooper's role was as the department's representative on the board in this board subcommittee. As it happens, he recused himself from the decision because I can't remember, there was some reason about the executive and the judiciary and stuff like that. But essentially, he would have been the conduit through which I would have assumed we were getting a departmental view.
Why did Post Office need a departmental view on whether to apply for a judge to recuse himself?
Well, I think this is simply an example of where matters had got very serious. So you have to see things in the context of the litigation producing an output from the first trial that was a loss on virtually every count, and our sole shareholder beginning to get concerned from all sorts of points of view. Not least, I imagine they could see that there would be significant reputation, significant cost, all sorts of things.
Was it right that your initial reaction, as is recorded here, is that this, i.e. applying to recuse the judge, was not something that the board was likely to want to do?
For the reasons I was trying to express earlier, I think most of us, I'm not trying to be overly complimentary, Sir Wynne, but most of us think judges usually get it right and, have an inherent respect for the judiciary. And so it would have excited a certain amount of unease in most people, I think, to go suggest that, the judge had got it wrong.
Well, and was biased.
Or biased.
What changed, to your understanding, from your unease at making the application and your reporting that this was something that the board was not likely to want to do, to the making of the application?
So the first point I should make is that, I also recused myself from the decision, but
just to stop there, that was because of your role
at
as chair of
HMCTS.
HMCTS.
But put that to one side. I was there. I would have been involved in the discussion. So that's a bit, I'm not trying to back out of this thing. So we had advice from two sources. We had advice from Neuberger, and we had advice from Grabiner. Grabiner's advice was pretty strong, actually. I think he said something along the lines that we had a duty, almost, to ask for the judge's recusal. And
Stopping there, what did you understand? You're right, he did say that. What did you understand him to mean by that the post office was under a duty?
I can't recall the detail exactly, but the way the advice was framed was that, we kind of almost to ensure the business of the administration of the law required us, where we thought something had been incorrectly managed for whatever reason, we needed to act upon that.
Just stopping there, and can I put two potential hypotheses to you in terms of the post office was under a duty to apply?
Yeah.
One could mean that the post office was, as a matter of company law, its directors, it owed a duty to make the application in discharge of its duties to its shareholder. Alternatively, it could mean that if you wish to win this litigation in the final result, procedurally, you are under an obligation to take this point now and not wait until you appeal the substance. Can you recall whether you formed a view as to in what sense you are under a duty to make the application?
Yeah. Honestly, I can't at this distance. I think I don't want to make too much of this duty thing. I think we just got advice from two very, very senior lawyers and felt, on balance, that advice should be taken.
So in answer to my question, the thing that changed was legal advice from two very senior lawyers, one of whom said that the post office was under a duty to make the application.
That's a fair description of what happened.
Thank you very much. The last topic, please. You told us earlier that you were not aware of concerns being raised about the Fujitsu employee, Gareth Jenkins, giving evidence in court in post office prosecutions that may have been false or incomplete until much later on. You couldn't remember when. Can I ask directly then that we look at poll 406375? my mistake, 6357. Thank you. If we just go to the last page, which is page 14, and foot of the page, we can see this as an advice of the 15th of July, written by Simon Clarke in a firm of solicitors that the Post Office used, Cartwright King, to advise it on matters relating to the prosecution of sub-postmasters. If we go back to page 1, it's advice on the use of expert evidence relating to the integrity of the Fujitsu Services Limited Horizon system. If we just look at page 13, please. And the author says, what does all this mean? It means that Mr. Jenkins has not complied with his duty to the court, the prosecution or the defence. 38, the reasons as to why Mr. Jenkins failed to comply with this duty are beyond the scope of this review. The effects of that failure, however, must be considered. 1, Mr. Jenkins failed to disclose material known to him, but which undermines his expert opinion, in plain breach of his duty as an expert witness. Accordingly, his credibility as an expert witness is fatally undermined. 3, in those current and ongoing cases where he has provided an expert witness statement, he shouldn't be called upon to give that evidence. 4, notwithstanding that the failure is that of Mr. Jenkins and arguably of Fujitsu, this failure has a profound effect on Post Office and its prosecutions, not least by reason of his failure. Material which should have been disclosed to defendants was not disclosed, thereby placing Post Office in breach of their duty as a prosecutor. 6, by reason of that failure to disclose, there are a number of now convicted defendants to whom the existence of bugs should have been disclosed but was not. They remain entitled to have disclosure of that material, notwithstanding their now convicted status. And lastly, penultimately, there are a number of current cases where there's been no disclosure, where that ought to have been given. Lastly, where a convicted defendant or his lawyers consider that the failure to disclose the material reveals an arguable ground of appeal, he may seek leave from the Court of Appeal. When were you first made aware of the existence of this advice by Simon Clarke concerning Gareth Jenkins?
Oh, well, I mean, probably in reading this in detail, when I actually got all of the, I can't remember, I think it must have been in my bundle. But, I mean, certainly years after the event, I mean, one of the things that struck me was I don't think Swift was shown this.
Correct.
Yeah, so, you know, yeah, I mean, I can't tell you exactly when, but suffice it as to say, I would imagine post the trials, probably.
And by the trial, do you mean the Horizon Issues trial?
Or both. I mean, you know, the point I'm making, I think, is that I would have known about this at the point at which we were reviewing stuff after the litigation, yeah.
Okay, so too late for it to matter then?
Too late for it to matter then, yeah.
What was your reaction on being provided with a copy of the advice or having it summarised to you?
Well, this is one of the things where, again, I think when you've looked at a lot of the documents that we have reviewed today, it's hard not to draw the conclusion that decisions might have been different had a lot of these things been known at the time. And, you know, this whole terrible raft of events, I think, in part, is because as problems build up over time, the wall against breaking them down gets higher and higher. And this was just part of the wall. And it didn't break down, really, until we got to the litigation, I suppose.
Can we look, please, at poll 0016 7395? These are minutes of a board meeting held on the 19th of November 2020 by conference call, and you'll see that you are present. It's a special meeting concerning the CCRC, and you'll see that there's quite the cast list. If we scroll down, and scroll still further, and then over the page. Second paragraph on that page, Brian Altman informed the board that a layer of complication had been added to the court proceedings yesterday. And then scrolling down, please. That paragraph refers to essentially the disclosure within the proceedings and outside the proceedings of the clerk advice. Okay? That's the earliest that we can see that a reference was made to the clerk advice in any board meeting. Would that presumably you wouldn't presumably be in a position to say, no, we were told about it much earlier?
No.
I mean, lastly on this point, if we look at UKGI 301 7966. UKGI 301 7966. Thank you. This is a reply of the Post Office to Tim McCormack, one of his searching freedom of information requests. And he says, good to see the new spirit of openness in action yet again this morning with the publication of redacted copies of board minutes. Could you therefore provide me with copies of all board minutes in which is mentioned the clerk advice or clerk review? So he's after that information. And then looking at the bottom paragraph there, Post Office Limited has conducted reasonable proportionate searches and has identified two sets of minutes in which the clerk advice was mentioned. The minutes of a meeting on the 19th of November, which is the one that I just took you to, and the minutes of a meeting on the 4th of February, which is obviously later in 2021. So it seems that the Post Office rather agree that the earliest mention of the clerk advice of July 13 to the board was the 19th of November 2020. When it was revealed to the board, the clerk advice, did anything happen as a result?
That's I can't answer that question, I think, because
I'm thinking, Mr.
it's
Parker, something like, well, hold on, I've been in position now, speaking from your perspective, for 5 years or so.
And how come I didn't know about it?
Yeah, I commissioned this guy called Jonathan Smith to look at things.
I get the gist of your question. All right. So look, this is 2020 or 21 or something like that.
November 2020, earliest mention.
Again, I have to put in context some of my answers here. Previous context I've given you is the Post Office wasn't just about Horizon. There were a lot of other very serious problems which I and the board were contending with. The context I'd give you on this is that I believe in 2021, we had 60 board meetings, something like that, to do with the fallout from this whole thing. So whether anything happened as a consequence of this, I can't tell you for sure. What I can tell you is that the amount of time and work and effort that I and other board members put into trying to essentially reconstitute this whole business from top to bottom might have allowed one of these things to sort of, just evaporate without anything happening as a consequence. So I can't tell you for sure what happened, but I can tell you this was an incredibly, incredibly busy time. You have to remember, if you take an organization and within the space of 6 months, you find out that the whole basis on which your business is being conducted was wrong, you find out that the whole basis of how you are somehow operating has to be changed. The amount of work to try and put things right, correctly so, I mean, all of these things needed putting right, but the workload was just immense and all time consuming. And whatever, I can tell you the new CEO and the new team were making strenuous efforts to try to put things right. So that's the context I would give, I suppose.
Mr. Parker, thank you very much for answering my questions. There are some questions from call participants. Could we take those, please, at 3:30, sir?
Yes.
Thank you very much, sir. Good afternoon, sir. Can you see and hear us?
Yes, I can. Thank you.
I'll just wait for the room to settle down a little.
Mm-hmm.
So the questions are, to start with, from Mr. Henry, up to 30 minutes, Mr. Steen, up to 10 minutes, and then Ms. Patrick, up to 10 minutes.
All right. Thank you.
Mr. Parker, together with Ms. Page, my junior, I represent of core participants, including Seema Misra and Mrs. Teju Adedeo. I want to start off with some general questions, if I may. The first is the Sir Anthony Hooper argument. Did it ever occur to you that the SPMs who ended up being prosecuted or milked for shortfalls were hardworking people trying their best to put food on the table for their families in their own self-reliant way? And therefore, why would they resort to stealing from their own businesses?
I think the way you put the question, there is with hindsight, it would appear that, and this was the scale point I was trying to make earlier, which is that if I had seen, I think, at the outset, how many people had been convicted and how many people had been terminated or had an employment issue because of apparent shortfalls, I think the scale of the problem would have been apparent. And I think part of the lack of response or immediate response partly came from this apparent scale, if you like, of how many people there were relative to the population of sub-postmasters. But you're absolutely right. I mean, when do you start to question whether people are honest or not? How many people do you need in a population before you think, well, can't be the case, they're all crooks or whatever?
Well, I'm going to come to that. And fortuitously, that was my second point. Because when notifying the government of the liability regarding convicted sub-postmasters, so not dealing with civil, but purely criminal, in your letter to the Secretary of State, you mentioned that 959 cases had been identified in which Horizon evidence had been used to secure a conviction. Do you remember that letter?
When was that written, please?
Well, we'll put it up on the screen. Yeah. It's POL 000 31104. And you can see it's 29th of April 2020. And if we scroll down, I can never get it right either, whether it's down or up, but you'll see that there is a reference to 959 cases. It's the penultimate line on the screen.
Yeah.
So I'm going to describe it as the epidemic of theft and false accounting. Do I take it from your answer, your previous answer, that you never questioned the conventional wisdom that this huge portion of sub-postmasters was dishonest, and that this statistically significant number of allegedly dishonest sub-postmasters did not make sense?
The point I was trying to make earlier, and maybe I didn't make it clearly enough, was that when I turned up and I asked for the SWIFT report to be done, and we did all of that, the way the problem appeared to me was that there were 130 people, I think, going through mediation, or 136, and there were 23 cases that were going through the CCRC. What I was trying to say earlier was that I actually didn't become aware of just how many of these people had been convicted until quite late in the day. And you might say, well, why didn't you ask? And that's the point I was trying to make. With hindsight, we could, and perhaps this question should have been asked, was that I know 23 people are going through the CCRC, but can you tell me, please, how many people have been convicted over the last 15 years? And that, might have precipitated a totally different response to this thing, because, as I was trying to explain earlier as well, you can look at it through the lens of, was the computer system reliable? Or you could look at it through the lens of, how come so many people have been convicted? And how does that compare with the average for people being convicted in a retail business, for example, which is one of the questions I ended up asking. So I know it's an unsatisfactory response to you and your clients, but if this thing ever happened again, and the issue was some people have been convicted, one of the first questions to ask is, well, out of a population of how many, and how many other people have been convicted who aren't complaining or aren't going through mediation?
So do I take it again that that work, that statistical analysis, came far too late?
I'd have to agree with you on that.
Right. Now, I want to move on to a different subject. And I appreciate that you were very much, as it appears, reliant on experts. But the recusal decision to unseat Mr. Justice Fraser, did you, notwithstanding the advice you received, take into account or recognise the impact that would have had on the sub-postmaster's ability to secure an outcome in their favour? In other words, did you reflect that if you had been successful, that would have killed the claim stone dead?
So I think one of the it's not a paradox exactly, but as I said at some point today, it always seemed to me that had this been managed in a more cooperative manner, the civil proceedings, it could have, and perhaps should have, ended up with a judge-determined set of decisions around the contract and the reliability of Horizon. Of course, what happened was it was an adversarial combat, and each side was trying to win. And the recusal was one decision that could have stopped your client's case dead. I'm sure there were other things that, had they lost, would have ended up with a termination to the claim. For example, if the judge had decided in the common issues trial substantially not to change the agency arrangement, that might have changed things as well. So my take on it is, you're right, you know, had the recusal thing been successful, it could have stopped the case dead. I mean, again, it must seem perhaps somewhat naive in retrospect, but my intention, and I had hoped with these proceedings that we would fight, you know, a sort of fair battle. And I think one of the issues was the legal teams got into a sort of we want to win litigation without at virtually any cost. And we got into a situation where people were doubling down, and the recusal thing to me was a doubling down thing in retrospect. So, you know, for me, this is one of the most unsatisfactory aspects of the whole GLO.
Did you feel, do I take it that you felt that you had, as chair, lost control of the litigation? Because obviously these things were being done ostensibly shorthand in your name, but you appear to, by your answer, suggest that the lawyers had got out of control and that they doubled down and it had been adversarial and that you had, together with your colleagues, nothing to do with it.
So, look, Mr. Henry, it's not my intention to release myself from responsibility for these events. When you're the chair, you know, the buck stops with me. So for me to try and characterise this as, oh, it's all down to the lawyers and it's nothing to do with us, that's certainly not my intention. I think what I'm trying to highlight is in the balance between the client and the lawyers. Sometimes the shift goes too much in one direction, and instead of being, you know, the dog, it's the tail starts to wag the dog a bit. And I think the tail was wagging the dog a bit when we got to this. The recusal thing, as I said, I think I had misgivings about it at the time, and it's again, I tried to make the point. I don't know how many judges are recused, but I imagine it isn't very many.
Now, Mr. Parker, moving on again to a separate topic, and I assure you that there is some purpose to it. When you sent out letters of apology subsequent to the Horizon Issues judgment, reflecting on this now, Mr. Parker, was that performative or was that a genuine expression of contrition?
So, the subject of apologies is quite interesting because today I was toying with making an opening statement. Stand up, you say, I'm deeply, deeply sorry, as many people have done. And there ensued a discussion with people, should I do this? Because, you know, I would like to say sorry. And the response I got was that, well, you could do this, but actually, you know, people have kind of got a bit tired of that, and it all rings a bit hollow. And you're probably just going to annoy people more than really give them any sense of your real desire to say sorry. And I'm afraid in these circumstances, it's very hard to either prove that your sorrow and apology is genuine. It's hard to find language which, if you attempt to express it in the extreme, just sounds as if you're being hyperbolic and simply trying to get effect. So there is no satisfactory answer to this. There is no real way to say sorry in a convincing way because the people who've been affected just feel the damage has been done, and you're scrambling to sort of fill a small gap in that sort of failure to accommodate. So I don't think a good letter could have been written. I don't think any letter would prove to be satisfactory. And it's not easy when you've got a lot of people who are involved. So I know that's an unsatisfactory answer, but I'm trying to express the reality of the situation.
When you signed those letters, though, did you remain of the view, even after the Horizon Issues judgment, that the sub-postmasters who've been prosecuted or pursued in the civil forum were guilty, liable? I mean, I'm trying to ask you to reflect on how hard it was to let go of the idea that the sub-postmasters who had challenged and who had taken on the post office weren't at it.
I see the point to your question. And my view is that once we had reached the end of the trials, the game was up, as it were. And it was time to just, I've tried to, when you get a business that is so upside down in terms of its structure and its relationships, I can see why you're asking the question. But from my standpoint, I felt the game, we just needed to change completely. And with the new chief executive and the team, we have tried, or we did until I left in 2022.
So you don't believe that a mindset of blame still persists? I know you left in 2022, but you don't believe that a mindset of blame still persists within the organisation?
I can't speak for an organisation. I can only speak for myself.
Yeah.
And it's, I would say that Nick Reed and his team have, at all levels, made a huge effort. Now, that isn't to say that some of the people who were working at the time of these events are still at the post office, because it's impossible to run an organisation, just clear everybody out, as I hope is obvious. But the mindset has been completely changed. And I would say when you have such a huge shift in culture to make, it's never made overnight. I mean, this is you have to appreciate, it's one of those slightly irritating aspects of these sorts of events, is that trying to put them right is no easy matter. And it requires determination at the top. And believe me, after the trials, I and the rest of my board and Nick and his team have done, I feel, as much as they can. The one area that I simply cannot speak for is money, because money, unfortunately, once the fact that there was a huge liability at stake, the money is no longer a matter for the post office, it's a matter for the shareholder.
I see. Well, I'm going to now go to a specific example where I suggest you see the mindset hasn't changed. Taking Mrs. Adedeo's case, what is your view on the Post Office's recent written submission to the inquiry, effectively branding her a criminal despite her conviction having been quashed? I mean, you may not be aware of it, but I can put it up on the screen if you like. But I quote, "The inquiry will be aware that this, that is Mrs. Adedeo's case, is the sole case study where the Post Office does not accept that the conviction was unsafe." Do you unreservedly reject that victimisation?
First of all, we haven't got the letter yet. And secondly, unless I have got all the facts at my disposal, Mr. Henry, I don't think you can expect me to, deliver a black and white response on this. And I'm no longer obviously at the post office, which precludes me a little bit from knowing what all the background is.
Well, Ms. Parker, her conviction was quashed, and the post office still brand her a criminal. I mean, surely can you not reflect upon that and distance yourself from it and repudiate it?
I think I'd love to be able to just say, yes, Mr. Henry, it's absolutely right. Your client, I'm absolutely with you. Honestly, I haven't had the background, and I simply much as I would love to sit here right now and say, yes, I would prefer to see the background first before delivering an opinion, and I hope anybody in my situation would see that's not unreasonable.
Well, if it helps, Mr. Henry, I think it's fair enough.
So be it, sir. Can I go to time, please, now? And I've got, having dealt with some general questions, some specific issues. Throughout your tenure, you had many competing obligations devouring your time. And you wouldn't be human if, from time to time, forgive the expression, they were distracting you. You would agree?
Actually, I've got a slightly different view to that. I would say one of the strengths of having multiple appointments is that you have got exposure constantly to what is going on in a range of different activities. And that actually means that you are well acquainted with the business world and other worlds, actually, and what's going on. And so I would say, and I tried to explain earlier, that, you know, being an effective chair is partly to do with time, but it's also to do with judgment. And I think one's judgments and one's involvement are actually improved by having a range of different things to do.
And that, curiously, and I'm sure that you weren't plagiarising it, was Mr. Leighton's similar explanation for the competing demands. But you have said yourself that it wasn't just about Horizon. There was an awful lot of stuff going on, awful lot of stuff going on in the business. And what I'm trying to suggest to you is that to reduce your time at this critical stage before the GLO must ultimately be viewed as a serious error of judgment. What do you say to that?
I say, actually, I gave, and as far as I'm concerned, Mr. Henry, I gave all the time and attention that I could and needed to at the post office. And I think if you talk to colleagues, look at the board effectiveness reports, just do a general trawl, go and talk to people at the post office, you will find that I was well acquainted with what was going on. I was always well briefed. When I was in a meeting, I paid very close attention to the facts that were under consideration. I chaired meetings well. So, no, I don't accept that assertion, actually.
I'm going to deal with this very quickly, Mr. Parker, but you are familiar, and you have seen, of course, in the pack that was sent to you, a number of emails from Mr. Tim McCormack. Mm. And what I'm suggesting to you is that because of the enormous burden on your shoulder, not just simply from the post office, but other competing demands, this affected your ability to grip it personally and get involved in what he was saying in a meaningful way. And so therefore you were channeling his requests onto other people who were not serving your interests. In fact, they were delaying, denying, and stonewalling Mr. McCormack. Now, would you like me to deal with the emails in detail, or...
Yeah, I understand, because I've read the emails.
You've read the emails.
And I understand the point you're making. Yeah. And I've tried to explain earlier that when I joined the post office, and bearing in mind most of these emails were probably around April 2016 and July or whatever.
Yes.
I think that's right. I assumed, perhaps with hindsight, incorrectly, that the people who were advising me were honest, were competent, etc. And in virtually every other company I have been in, when I get a sort of email or letter that comes in which is essentially about a legal matter and says, in capital letters, I will say, what's going on, and take it away and give me some background. And I understand the point you're making, but I can honestly tell you, Mr. Henry, that whilst it might appear that we should have grappled with Tim's points and really concentrated on them. And it's very unsatisfactory looking back to see that it was handed over to a bunch of people that we, arguably weren't going to handle it well. Those were the circumstances at the time. I'm not trying to get out of responsibility here. Some mistakes in that respect were made. But I honestly wouldn't say that was a function of me not having enough time as such.
But if it wasn't a function of you not having enough time, then why would you not wish to go to the ends of the earth to establish whether or not an innocent woman had been imprisoned?
Because this was an individual case, which I think was going through the CCRC. I can't quite remember the context. And actually, I have tried to grapple with this thing largely through the collection of issues that were brought together. And you're right, I mean, perhaps had one rushed after the Misra case, there might have been some progress. I can't honestly tell you. But if what you're implying is that somehow, because I didn't deal with this thing, we didn't really do anything, didn't really care about this, didn't try to resolve it, I don't think that's really fair.
What I'm trying to suggest, you've talked about the wall being built. We've seen how your reception into the post office was being prepared. I'm going to call it a grooming pack, prepared by Mark Davis, that they were trying to get you on side. And that notwithstanding your genuine desire to be independent, notwithstanding the fact that you had no axe to grind, that gradually you were compromised, and to use the analogy of the wall, you became immured in prejudice. What do you say? The institutional prejudice of those people that you relied upon and trusted, who surrounded you.
What I will say is this. Behind a set of events that we have been discussing today are a complex mixture of interactions between people. Some self-consciously driven in a particular direction, others not, others just being part of it. And so, whilst your characterization, I think, probably has some truth to it, matters are far more complicated than that. And I would say, in some respects, yes, the wool might have been pulled over the eyes, and in other respects not. Sometimes happened, sometimes didn't. But there isn't it's very unsatisfactory, but it's like, here's a set of wrongs, and we put them right, and how do the wrongs happen, and exactly, where are the root causes? And the root causes of this thing, of course, at the end of the day, probably reside in the software. The root causes of the problems we've talked about today reside in the process of investigation. The individuals, and this is the point I was trying to make, a lot of the problems that we have looked at happened between 2000 and 2010, quite historic. And trying to overcome history in a business when history is so damaging is a tough thing to do. So,
and all the more reason, therefore, for people who feared what impact that could have on the GLO to keep it battened down, to keep it hermetically sealed, so that none of that would escape. Do you see?
I do. I understand the point you're making, and I tried to express this earlier, which is it's got a slightly unsatisfactory tinge to it because, of course, it implied that Sir Alan and the JFSA team had to spend money and had to get support to mount the GLO. But the GLO, although one might have a lot of aspects of dissatisfaction about the way it was run, actually did end up with a judge making determinations which will change the post office forever and actually set up a situation in which your clients in time, should be properly compensated because there's been an absolute clarity in terms of what was responsible for what.
Ms. Parker, I have to be brief, and I don't want to be unfair to you, but I've only got a couple of minutes left. So I just want to ask you if you feel that the answer you gave to Mr. Beer about that this really had to be resolved, as it were, adversarially, was somewhat fatalistic, and that more could have been done to strive to see the other side and to strive for settlement without having to enter into the quagmire of litigation.
Yeah, I mean, there's no satisfactory answer to this. I played out, so if there had been an early settlement, I could easily imagine a situation in which your clients would be worse off. Because instead of waiting until the end, when it was absolutely determined by the judge that Legacy Horizon was not robust and Horizon Online wasn't robust, you could have ended up in a situation where computer system quite robust. This is the point I was trying to make earlier, where I played out. So the post, and I know I'm not trying to escape, responsibility, but if we'd sort of said, well, we think we've got a problem with the computer system, it's not reliable. The moment you start to get to there could be miscarriages of justice, there could be a huge liability here, then the question starts being asked, well, what's involved?
Could I, final question, please? And I have to compress two documents, but there are two documents noted by Peters and Peters, it would seem, but involving a number of lawyers. And one reference is POL 0033745. It's dated the 24th of January 2020. And so that's long after the Horizon Issues judgment. You are not present, Mr. Parker, but you and Mr. Cooper, it is said, wanted to take pot shots at Seema Misra. Do you have anything to say about that? Do you recall any research being done on what claimants, convicted claimants, had said in open source material to try and trawl to see if they had made previous inconsistent statements so that their credibility, even after the Horizon Issues judgment, but before the appeal, the criminal appeal, could be impugned? Do you remember anything of that nature?
I don't, and funnily enough, this document appeared fairly late in my bundle. I did have a look at it, and it is apparently a sort of abbreviated description, isn't it, of barristers' meeting, I think. Yeah. Yes. Well, look, somebody writes taking pot shots. I don't know what that means to you, but it's a fairly colloquial sort of, I don't know what they were trying to express, but I'd love to have Tom Cooper in the room here, but I can assure you, neither of us, would have been attempting to deliberately somehow undermine a situation that had been, effectively determined as a result of the trials. I think I just don't know where that comes from, honestly.
And finally, do you recognise the suggestion that the board looks at lawyers purely from this perspective? They see lawyers. This is Roderick Williams speaking on behalf of the board. Sees lawyers as interchangeable tools for optics. Legal advice is polluted product for the Post Office because of the High Court litigation. Is there any suggestion that you and your colleagues did see lawyers as marionettes?
Can you, sorry, what's the point? What's the point you're trying to make?
The board is reported to have told the lawyers not to advise on safety. And Roderick Williams goes on to say, quote unquote, the board sees lawyers as interchangeable and tools for optics. You said that you didn't see lawyers as marionettes, but I mean, this suggests that perhaps if this note is a fair reflection of your point of view, that you did?
I don't think, is this a Roderick Williams note, is it? I don't think Roderick really reflects an awful lot of what certainly I think or the board thinks.
Okay. I think I've run out of time, so I'm going to stop there. Thank you, sir.
Thank you.
Thank you, Mr. Henry.
Mr. Parker, my name is Sam Steen. I ask questions on behalf of a large group of sub-postmaster mistresses and people that worked in post office branches. You'll recall having dealings in at least 2019 with a Mr. Swannell. At the time, he was the chair of the shareholder executive, and that was later renamed into UKGI, which is the UK Government Investments. Okay? Now, when you get to the end of 2019, there were discussions that touched on the question of settlement. Do you recall that? Okay. Now, help us please a little bit with this. Mr. Swannell will be giving evidence next week, I think on Tuesday. And his recollection is of having had a word with you sometime in June 2019, whereby you thought the estimate of the amount involved in the settlement might well be something in the order of 100 million. Now, contextually, we know that the settlement was in the order of essentially 50 million. Okay? Now, that's quite a big difference. The 100 million, was that what you thought it was worth, or was that what was you were told this may well come to?
Honestly, I'd like to see the papers because it's quite hard for me. 2019, 20, 100 million. I'd love to be able to give you a definitive answer, but I can't on that.
But do you have a recollection? Because it's only his statement where he refers to this. I'm not sure we have papers that refer to this. You give a recollection as to whether there was any particular barrier, as an example, to 100 million or
all I
that
will
was being
say,
discussed?
Okay, all I will say to you, and again, I'm not trying to, escape responsibility or liability or whatever, is that whatever discussions happened post the litigation, the whole the money only comes from one source, and therefore, whether the post office quotes the number or there's another number, ultimately the decision isn't going to be made really in the post office.
Right. So essentially, you're saying by that point, it's for the government as the shareholder.
The post office could not probably run, and maybe it can now, but certainly in my time there, I don't think it could have run as a standalone business. It needed constant support from the government.
Right.
And therefore, any additional cash requirement was always going to be an incremental government decision, one way or another.
So before I move on to another topic, your recollection of the figures in relation to the settlement was, one, the money was always going to have to come from government. Yes? Is that right?
Ultimately, yes.
And secondly, Mr. Swannell's recollection of discussions around 100 million, and in fact it being considerably less than that, clearly demonstrates that there had been discussions at potentially quite a bit of a larger figure at some point.
Look, I don't want you to put words into my mouth that are subsequently contradicted by someone else, so I can't give you a definitive answer to this, honestly.
Okay, but you're not saying no. What you're saying is you can't really remember. Is that fair?
That's exactly what
All
I'm
right.
telling you,
Okay. Now, I'm going to go, therefore, to a document you've looked at with Mr. Beer a little earlier. Can we go to POL 00174-397, please? And I'd like to go to page 2 once we get to the document. So do you recall quite early on in the questions being asked by Mr. Beer that he was discussing with you this note, which is a note that was meant to have emanated, as you understood it, from Miss Venables, Paula Venables, okay? And it's a briefing document of some type, setting out some of the concerns at that time. Now, you said repeatedly a word you use is context, so let's understand the context of things. So the context of this note is you come into a business that's overall in crisis. You agree?
Yes.
Yes. Fundamentally, this is a problem business in terms of needing to be turned around, yes?
Yes.
Okay. You've been chosen over another possible candidate as being the right individual to have a go at doing that, yes? And you
Yes.
wanted to find out more about what's going on. Again, you're saying yes, you agree.
Yeah. I'm just wondering where this is going.
Well, let's see where it's going in a moment.
Yeah.
We know also from your evidence that you've said that the whole basis of the business and the way it was being conducted, you referred to that being questioned in the litigation because it's about the Horizon system.
Yeah.
Okay? So when you came into the post office in the role that you took over, you must have realized quite rapidly that questions regarding the Horizon system integrity were also questions that were threatening the whole business. Is that fair?
Looking at this, as I've tried to explain, in scale terms, it didn't look that big in relation to the population of sub-postmasters, the number of people who were complaining, the number of people who were convicted. And most of these issues were to do, obviously, with what you would call historic Horizon. So, from my perspective, we had a set of issues that were people who'd had historic problems with Horizon, and then there was Horizon as an EPOS system, which operated post offices, effectively. And the two things are one is sort of business as usual, the other is a whole set of issues that people had with the system historically. So this, as I tried to explain earlier, this was one of a number of problems.
Right. Now, you said that a number of times. That's your context point, number of other problems dealing with the business. But this is about the Horizon system. It's questioning the integrity of the system. You agree with that?
A component of it is.
Let's have a look at how serious this was then. We go perhaps to the bottom of page 2, if we may, please. I think we're there already. And fourth paragraph from the bottom. Just go up a little bit. Yeah. We see the bottom. That's it.
Yes.
Right. So we can see that the references here, obviously, to the JFSA campaign.
Yeah.
We can see that the BBC Panorama programme. We can see references to MPs that are also engaged. And scroll a bit further down, please. It's my fault. Let's go up again. Fourth paragraph from the bottom.
Yeah.
Yeah. Okay. So the one that starts, we've been robust in rejecting the serious allegations made in Parliament.
Yeah.
See that one?
Yeah.
Made in Parliament and media, particularly in recent months. And then it goes on to talk about the issues that concern the campaign's allegations have grown to include suggestions of wrongdoing by senior management, bullying, deliberate cover-up, and abuse of prosecutor powers. Now, these are serious allegations.
Yes.
Now, accepting your point, which is that in your mind, you've got a problem which is you think may well be largely historical, maybe an older part of the system. Okay. But this is, in fact, actually questioning the integrity, not only of the Horizon system, but also of management at the very time you're coming into it. So it's raising the very question that Mr. Beer was talking about with you, which is, well, hang on, are the people around you people that you can trust? Right? Serious allegations.
Yes.
In fact, allegations that, if true, would be the death knell of the business that's already in crisis.
Well, I'm not sure I would go that far, but you're right to highlight that, yes.
Okay, well, let me highlight then and see if I can be right about something else. Page 1, third paragraph down, please. Now, I use the term paragraph, the three main paragraphs from the top under note for Tim Parker. Okay. So it says this: the Horizon system deals with 6 million transactions every day and has been used by almost 500,000 people since it was introduced. Currently used by 78,000 people working in post office branches. It is independently audited and meets or excels standard industry accreditations. Let's take that apart. Did you receive the independent audit of the Horizon system at this time?
No.
Did you ask for the independent audit of the Horizon system at this time?
Which independent audit system are
Well,
you referring
go back to
to?
the third paragraph from the top, the one I read out. The Horizon system deals with 6 million transactions every day and has been used by almost 500,000 people since it was introduced. Currently used by 78,000 people working in post office branches. It is independently audited.
Okay.
I'm stopping there for the moment. Did you see the independent audit
So,
at this time?
essentially,
It's a bit of a yes or a no question.
No, can I just finish,
Yes, Mr.
please?
Clark.
I think I'm entitled to that. I understand the question that you're asking. Essentially, I didn't ask for the independent audit. This was something, obviously, that's been put into the brief. Now, I'm not quite sure. Can you just explain to me where you're going? Yeah, I don't.
I'm asking the
yeah.
simple question. I suspect the answer is either yes or no.
Yeah.
It looks like it's no. Did you see the independent audit? The answer appears to be no, you didn't. Is that fair?
Well, if somebody says something is independently audited,
Yes.
that can mean a number of different things. It can mean somebody's gone in and looked at it, or it can mean there's I don't know. But if you're asking, had I got the independent audit? No.
Did you ask for it?
I don't think I could have done.
Right. Why couldn't you have done, Mr. Parker?
Do you know,
Is that you saying you didn't have the power to, or you saying
No.
that you just didn't?
no. This was a brief that I received, and we've looked at this Sparrow brief, and it's, earlier. And this is all about, so what actions could have been taken that might have landed us in a different direction? And maybe you're right. Maybe there was an audit. We could have asked for it. I could have asked for it, and it would have said, this is okay, or it would have been something that was inadequate. I'm not entirely sure. And with hindsight, there are many things that we could have done. SWIFT, which we discussed extensively, whilst not being perhaps brilliant and perhaps a bullseye and perhaps spot on, covered off a lot of the bases. And if the question you're asking is, is there something that definitively could have been done that would have pushed us in another direction, I'm not entirely sure.
Mr. Parker, I'm asking about your decision making. I'm asking about your responsibility.
Yes,
I'm asking questions that go to whether and to what degree
yes.
that you have made mistakes. Do you understand that?
I
So
entirely
your answer to my
understand it.
question to the independent audit was this: I don't think I could have done. Now, I'm trying to find out now, with my follow-on questions, whether that means you didn't have the power to do it or you just didn't do it. Which?
I think I could have had the power in theory, I suppose, to do many things.
Right.
And we, as I said, I didn't ask for the audit, and it, I don't know what this was referring to. We moved on to SWIFT.
Okay. Now, it then goes on to say this paragraph, and meets or exceeds standard industry accreditations. Do you ask for those?
I can't tell you right now because, this is a long time ago.
Do you recall seeing the standard industry accreditations for the Horizon system?
I don't think anybody plonked them on my desk, no, but I'm not entirely sure. I don't think so.
2 paragraphs down, we commissioned, it starts. You see that one there? So further down, we commissioned, thank you very much. So it's got a little yellow dash to the left of it. We commissioned, past tense, a review by independent forensic accountants. Okay? Then it goes on to set up a scheme which, where appropriate, offered mediation, etc. All right. Now, reminding of us of the timing of this. This is 2:15, at the time that you're engaged in dealing with matters. All right? We know that what this must appear to be is Second Sight, which is back to 2013. So it says we commissioned a review by independent forensic accountants. Did you ask to see that?
The Second Sight report we saw as part of the whole setting up of the SWIFT review.
Did you see it as part of this? Do you get this and say, I need to see the the independent forensic accountant review?
I can't tell you exactly when I saw it.
Right. So what we have established in your evidence with Mr. Beer, first of all, and obviously with me as well, what we have established is that you came in, you were given this briefing, and then you decided that you needed to have somebody else look at these issues, and that was then Mr. Swift.
Yes.
QC, now Casey.
Yeah.
Right, okay, got it. Do you accept that what you should have done has been more hands-on, saying, let's have a look at this stuff myself, I want to see it on my desk, I want to talk to the IT people, maybe talk to Fujitsu? Do you accept you could have gone more into this yourself?
I have tried to explain earlier, I think, that whilst you might say the Swift review was inadequate and we should have gone straight to the IT system and done an audit, that is one of a number of possibilities. And what I tried to do was to get somebody who could look at the range of issues, and the Horizon system was one of them. So, you know, if I had seen, I suppose, and I mentioned this earlier, the scale of the thing, that might have been different. But I responded to this, honestly, in the best way that I thought I could. And I felt Swift was a pretty good response initially. Now we know, with hindsight, we go down this sort of sparrow briefing. I can see your point.
You see, one way to look at the difficulty with the amount of time that you were spending on this is that you were part-time and your decisions were part-baked.
Yes.
I understand that, Mr. Parker. You've said repeatedly that the time issues, this is the same amount of sort of time that you might spend with other businesses, that the role of the CEO is like that you have a direction rather than necessarily getting down to the grips with the nitty-gritty all the time type role. But this isn't the National Trust, is it, Mr. Parker? This is the Post Office, responsible for prosecuting its own staff members. Don't you think that more time should be spent by you getting to grips with these very issues?
I don't accept that. I
Right.
gave sufficient time and attention to the Post Office. I'm sorry.
Our time is limited now, myself, in relation to questions. I'm going to take you...
You've already taken double the allocation, Mr. Stevens. So one more
only
question.
one more minute. You say this in your statement, paragraph 59. This is in relation to the Swift report or review. And you quote in your statement part of the Swift review, where it says this, in relation to bugs. So paragraph 59, page 27 of your own statement, all right? Swift review. It seems to us entirely unremarkable that the Horizon system, which is enormous in terms of the range of matters it deals with and the number of users it has, will occasionally discover bugs, errors, or glitches in the way that it works. And then you continue the quote. Some of those bugs may impact on the financial position of a branch, either positively or negatively. We do not understand Pole or Fujitsu to suggest anything otherwise. Now, Mr. Parker, we're learning from the Swift review that this system, the Horizon system, may in fact cause negative impacts on the financial position of a branch. Did you not think to yourself, hang on, that sounds remarkably like the people that have been making all that noise from the JFSA, and decide there and then to do something about it?
So Swift, I felt, covered off a range of issues and covered them off quite comprehensively. And I took away, perhaps wrongly, that Swift, whilst it wasn't a green light, was not a red light either. And what you've done today, I think, has sort of picked up on a number of points which, with hindsight, we might have gone after. And this is one of the frustrations and difficulties of looking at something like this over a long period of time with a great deal of complexity. And, you know, I could reel off a bunch of other things I could have done that would have ended up with probably a quicker situation. But I come back to the point I made earlier, which is that the extent of the issues that we had arrived at meant that no matter how unsatisfactory, the ultimate determination of the reliability of the computer system and the contractual position with said postmasters has facilitated a long-term solution to this problem.
All right,
So thank you for your indulgence. No further questions.
Oh, that's fine. Ms. Patrick.
Thank you, sir. Mr. Parker, my name's Angela Patrick. I represent a number of sub-postmasters who were convicted and have since had their convictions quashed, included Mrs. Hamilton, who I'm
Yeah.
sure you can see sitting
Yeah.
beside me.
Yeah.
You might be glad to hear that I only want to look at one issue. I want to turn back to the follow-up to the SWIFT review. And I actually only want to look at one example, and that's the advice of Mr. Altman, then QC, now KC, produced on the 26th of July of 2016 for the Post Office in response to the SWIFT review. And I want to start just to look a little bit at what you say in your witness statement about that advice.
Yeah.
Just to refresh your memory. I'm not proposing to turn your witness statement up in
Okay.
case you need me to
Yeah.
refresh your memory.
Yeah.
If you do, say so.
Yeah.
In your witness statement, you say, and it's at paragraph 113 for those following along, that it's likely that you would have been briefed on that advice from Mr. Altman, but you can't recall now what you would have thought about it.
Yeah.
Now, just to clarify, do you think you did see a copy of the advice, or is it likely that you didn't?
I mean, I'd like to be able to confirm to you one way or another, but I honestly can't.
No. But you would have been, you recall that it's likely you would have been briefed.
Yes, let's say, let's work on that principle if you want to take your point further.
It's not principle, I'm going on
Yeah.
your evidence from your
Yeah.
witness statement,
Yeah.
Mr. Parker. And in your witness statement, you say you'd probably have been briefed by General Counsel.
Probably.
Now, elsewhere in the witness statement, you reflect on the advice, reading it now, having been provided with it, and you can't remember if you had it at the time, and you reflect on the broad conclusions, and you note that there are some criticisms that Mr. Altman made that went beyond the scope of his instructions. And I just want to ask you about a couple of things,
Yeah.
two things
Yeah.
from the advice.
Yeah.
First, in your witness statement, you note that he reviewed 8 files,
Yeah.
and he considered 3 cases.
Yeah.
Yeah. Now, Mr. Beer took you this morning to some correspondence which you didn't see, narrowing the scope of Mr. Altman's instructions to cover 19 cases, if you remember. You hadn't seen that. Did you know at the time, if you can remember, that the scope of his advice had been narrowed still to 8 cases?
Honestly, I don't know, and I can't tell you.
No. And you can't, I assume, recall whether the briefing would have covered whether the review, the advice, had been narrowed to report only in 8 cases.
I can't.
If you had known, and you'd been told at that time, having read the SWIFT review and what he'd recommended, that you go back and
Yeah.
look at all the cases,
Yeah.
if you'd read at the time that he was only going to look at 8 cases, in fact, he could only analyse
Yeah.
3, would that have caused you any concern?
Well, it's funny you should mention that, because I read through the documents again, and I was struck a little bit that, you know, the case population wasn't enormous. I did note that.
And if you'd seen it at the time, maybe it would have caused you to ask, hang on a minute, can we really rely on these headline conclusions?
Well, I've tried to explain that I think one of the core issues with this thing was was percentages of the populations of people that were actually looked at. So, you know, as we've discovered, a huge number of people.
If I can pause you there, stop you there, Mr. Parker, whether it was 136 or it was 900 and odd,
Yeah.
if you were getting, I'd like to say,
Yeah.
probably expensive legal advice
Yeah.
with criminal silk,
Yeah,
on the advice of Mr. Swift,
yeah,
on whom you were relying, that all the cases should be reviewed,
yeah.
and you were being told that only 8 cases were being looked at, and in
Yeah.
fact he was only going to analyse 3,
Yeah,
would that not have set up a red flag for you?
yeah. Well, I said I looked back at the advice, and it you know, you're right to point out at the time it seemed relatively reassuring. Yeah.
But if you had seen it, would you have not said, hang on a minute, we're only looking at 8 cases?
I might have done, yeah.
Okay. Does that help with your memory as to whether you read it or didn't read it at the time?
Honestly not, no.
Okay, turn to the second thing I wanted to ask
Yeah.
you about. Now, Mrs Hamilton was one of the 3 cases.
Yeah,
And I only want to look at one part of the advice which deals with the circumstance of Mrs Hamilton's plea only being accepted on the condition related to repayment of money.
yeah.
And it's at Paul 2022854, and I'm going to look at page 27. If it's okay with you, Mr Parker, for time, I'm just going to take you to the 2 paragraphs I want to look at. You can trust me that it's the advice. If somebody could bring that up, I'd be grateful. And I want to look at page 27, and it's paragraphs 106 and 107. Thank you. And I'll just take it briefly, I'll read it so everybody knows what I'm talking about. He says, the proposal here, however, ultimately to invite the court to order the count to be left, that's the count of theft to be left on the record, on the file as a condition of repayment, was highly unusual, if not exceptional, and it was, it seems to me, fraught with difficulty, despite the judge approving the course. First, the effect of the arrangement was that the prosecution was in effect allowing Mrs Hamilton to buy her way out of a charge, upon which the in-house lawyer and counsel had advised there was sufficient evidence. Second, the question might be asked why, if the prosecution felt the evidence was sufficient to support the count of theft, it was content to drop it for repayment of the losses. Third, if Mrs Hamilton did have a tenable defence to the count of theft, although I've seen no defence statement providing any defence, undoubted defence statement was ever served, then it might be argued that the suggestion she should repay the losses in return for the dropping of the theft count, I apologise, I'll pause. For the dropping of the theft count, which was an idea originating with prosecution, placed undue pressure on her, despite the fact that she was represented and despite having pleaded guilty to false accounting. Now, I apologise. Now, that's an important, serious criticism, isn't it, Mr Parker?
Yes, I mean, he goes on. I mean, it's quite hard for me to comment on this. There's a lot going on in this paragraph. There's a lot going on the whole page. And I haven't got the whole document at my disposal. So to ask me to comment, on a specific case, I think is, unless we have proper time, and I'm not, go on.
I simply wanted to ask,
Yeah.
did you see this at the time, or were you briefed on it, and would you, if you had been, have considered it a serious matter?
So I can't tell you if I saw it, and before opining on how serious a matter I would have considered it, I'd have to look at the whole document again.
Okay. Did your briefing at that time, I know that you can't remember it, but just to try and prompt your memory, can you record any discussion of specific matters or criticisms that ought to be considered for referral to the CCRC?
No, I can't.
And you've spoken today about the advice you were given on privilege in the civil litigation.
Yeah.
Did that briefing or any advice you can recall being given around the time of this advice cover the Post Office's continuing obligations on disclosure as a prosecutor?
I can't, I'm sorry.
At this time, when you were being briefed or when you read this advice, you would have been aware, I think, that the rest of the board wouldn't have read the SWIFT review or its recommendations. Is that right?
Possibly, why?
Well, you knew that they hadn't, that only the 4 internal staff had been given it. You had a copy. It was being controlled. You knew the rest of the board hadn't seen the SWIFT review. Is that right?
But I'm sorry, what's the point you're making there?
I'm asking you a question.
Never mind about that, Mr. Parker. Just say yes or no.
Okay, yes. Or
Yes, you
no.
knew.
Yeah.
So, at that point, nobody else on the board could have judged if Mr. Altman had or had not done what Mr. Swift had recommended, could they?
Well, I'm not sure who the Altman advice was shared with, actually. This was one of the outputs of the SWIFT review.
That's why I put the question in the way that I did. You had seen both the SWIFT review and were being briefed or had been shown a copy of the Altman advice. You were uniquely placed. Nobody else could compare the two and say, well, Mr. Altman's kind of not done what the SWIFT review expected him to do. You were the only person that was in the position to do that, apart from staff. Is that fair?
Yeah, I think at the time I just took this advice, which seemed to me to be an adequate response on the first and second recommendation. I think, you know, I wasn't busy comparing things. It just looked to me, and I think I was told at the time this met the brief.
Well, Mr. Parker, I'm not trying to be flippant here, but you're saying comparing one thing or the other. This is a very serious question of whether the Post Office had met its prosecutorial duties to people who it had convicted of criminal offences. So being the only person on the board who could assess whether or not the advice that the Post Office had commissioned was actually what it sought to obtain, put you in a particular position. Did that at the time cause you to think that you really ought to be looking really critically at the advice the Post Office was being given?
I can't honestly tell you.
Okay, today you've relied a number of times on a belief that legal advice given to you was competently given in good faith. Did you owe any responsibility to the board and to the business and the government shareholder to actively question or challenge that advice you were being given?
I think, as I explained earlier, to challenge advice of specialists invites the question, you know, how do you challenge a legal opinion? And I don't have an easy answer to that.
But at a minimum, you would have had the responsibility to at least properly consider the advice you were being given in good faith. Is that fair?
And I believe I did at the time.
And you can't recall now if you ever saw a copy of the Altman advice?
I can't for sure.
Can you recall if you asked to read it for yourself?
I cannot. I'm sorry.
Thank you, Mr. Parker. Thank you, sir. I have no more questions.
Thank you, Ms. Patrick. Is that it, Mr. Beer?
Yes, it is, sir.
Well, thank you, Mr. Parker, for making a full and detailed witness statement and for answering questions during the course of today. I'm very grateful to you.
Thank you.
We'll resume, I believe, next Tuesday. Is that correct, Mr. Beer?
Yes, 9:45, please, sir.
Very well. 9:45 next Tuesday. Thank you.
Thank you, sir.